motion for the removal of deputy president. My Lord, that motion, before it is determined, public participation must be conducted. So, my Lord, the obligation of Parliament is to ensure that that motion goes to the people, for them to air their views on what they think the motion, on what they think the elected members should do with the motion. And my Lord, sovereignty, they exercise it directly or indirectly through their elected representatives. So, my Lord, there is no obligation whatsoever to send a response to the people, because by that time, there are no proceedings contemplated in the standing orders for pre-impeachment public participation, because there is no motion. It will be speculative to go to the people with a motion which has not been introduced to the House for adjudication. Just like this court cannot adjudicate, my Lord, on a petition which is not before it. People will be talking to the media about the petition, but the High Court will only be seized of that petition when it is brought before it. My Lord, that is very important to distinguish. And my Lord, the efficacy of or adequacy of this public participation considered at this stage of the proceedings. My Lord, the petitioner is inviting you to make conclusive determination on the question of public participation. My Lord, the response from the National Assembly that public participation was indeed done, and the mere fact that it was done, then, my Lord, you cannot consider that on merits at this stage. So, my Lord, we urge that you don't grant the conservative orders. So, my Lord, the application of the conservatory orders will to destabilize the process which is before the Senate. My Lord, there is no timeline, there is no guideline on what happens when the court has issued conservatory orders. What happens to the timelines in Article 145? What happens to those timelines when conservatory orders are issued? My Lord, the doctrine of proportionality in the Mutunga rules require that you exercise some restraint as not to issue conservatory orders at this stage. My Lord, Senior Counsel Paul Muite talked about gross violation of the Constitution as one of the grounds. He says the motion does not meet the motion for impeachment. But, my Lord, again, in the Sonko case, the Supreme Court has said the role of the court is not to look at the merits of these allegations. My Lord, instead, the High Court is supposed to just look at the process issues. Has the National Assembly complied with the standing orders and the provisions of Article 145? My Lord, if the answer is yes, then, my Lord, you allow those proceedings to continue and conclude. But now that my colleague, Senior Counsel, talked about gross violation of the Constitution, my Lord, allow me to say that indeed, from the motion, the Deputy President, there are serious allegations that the Deputy President is facing. And, my Lord, as I wind up, my Lord, the Deputy President is participating in the proceedings before the Senate. My Lord, that is important. He is participating in the proceedings before the Senate as well. So, my Lord, he cannot approbate and reprobate. He cannot participate in the proceedings before the Senate. My Lord, yes, my Lord, the process is going on. My Lord, allow me to quote a document, my Lord, which, because I'm not speaking from the back. Yes, my Lord. Yes, my Lord. From a response which was filed, which we have filed, and which also my colleague have filed, my Lord, an affidavit, supplementary affidavit by Gachagua. My Lord, this is what they have annexed. My Lord, they have annexed a letter from the Senate inviting them to submit a response by 5 p.m. today, stating that the motion is before the House. They were given material which constitute this motion, and they were required to file a response. My Lord, under Article 145 of the Constitution, those proceedings have already commenced. My Lord, what I'm saying is that the 10 days for the Senate to consider that question have already commenced. The proceedings are active before the Senate.
The idea that as to whether it's actively engaged, what you refer to a document that you have been invited.
Yes.
Not a document that has filed.
That's correct, my Lord.
So can we restrain ourselves to that point?
Okay, my Lord. I'll rephrase then, my Lord, by saying that the Senate has invited the Deputy President,
that's fine.
yes, to appear, my Lord, before it to answer on these weighty allegations which the petitioner says concern gross violation of the Constitution. My Lord, now that brings out a fundamental point. My Lord, he has opportunity in accordance with the provisions of Article 50 of the Constitution. My Lord, he has opportunity to air his grievance in a trial process at the Senate. My Lord, that's a fundamental tenet of the doctrine of natural justice. He has been given an opportunity to come and ventilate his concerns about public participation, content of their motion, the allegations he is facing. He has opportunity to ventilate those concerns in a quasi-judicial process, my Lord. My Lord, quasi-judicial process. So, my Lord, it's better that we allow him to exercise his opportunity to appear before this quasi-judicial process for the trial of these allegations. My Lord, the issuance of conservatory orders will deny the parties that opportunity to subject the allegations against him in a constitutionally tested and compliant process of impeachment. My Lord, the senators act as jurors, as in this case, stroke judges. My Lord, they are required to make up to decide on each and every allegation that he is facing. So, my Lord, the doctrine of ripeness then applies against the Deputy President at this stage of the proceedings. My Lord, his complaint is not ripe for judicial adjudication yet. My Lord, as I wind up, the roof is not on fire. My Lord, the courts of the doors of this court have not closed at him to come and ventilate his concerns about the entire process completed. But after the impeachment proceedings have concluded. And my Lord, this is the tenor and the effect of their submit in petition 522 of 2024. Whereas conservatory orders were sought, they abandoned the quest for conservatory orders in 522 of 2024. My Lord, the questions concerning public participation have been certified as raising substantial questions of law in 522 of 2024. My Lord, there's a prayer on arresting, suspending, or interfering with the decision of arresting, suspending, or interfering with the decision of the Senate in 522-2024. And my Lord, those proceedings anytime now will be before a 3-judge bench for adjudication. My Lord, to the extent that that prayer is live in procedure actively pending for another bench, then in these proceedings, they will be doing what we call lemon selling. If they seek conservatory orders, these proceedings, they'll be doing what we call lemon selling. My Lord, I rest a case and pray that you don't consider granting the orders for conservatory orders at this stage. Indeed, my Lord, if there's any decision with respect to consolidation, my Lord, we concede that this petition can be consolidated with petition 522, my Lord, for good order, my Lord, so that there is no conflict in terms of decisions which are made by the High Court on the same subject matter, my Lord. My Lord, with respect to the same petitioner, my Lord, the same petitioner. Thank you, my Lord.
Yes, my Lord. Yes, I have my time.
I wanted to ask a question.
Yes, my Lord.
You refer to paragraph 93.
Yes, of the...
Although I understand what is being said.
Yes. The flip side is that these standing orders then enjoy the presumption of constitutionality, unless they are impugned and a case made. Because at the time, for example, at the time of processing this motion, this was the standing order which was applicable. And therefore...
I just wanted to understand.
Yes.
That's what I see here.
Yes, that's correct, my Lord.
Thank you, my Lord.
You said you want to have 30 minutes.
I'll try and be brief since my colleagues have
What
covered.
are the three things that you have to say?
So one is on jurisdiction, my Lord. So I think I'll take less time because it's been covered. And on jurisdiction, I wish to rely on the decision.
Just say you have your 30 minutes.
Okay, thank you, I appreciate it.
If you want to bring it back to us,
Yes.
you will have to.
Thank you, my Lord, I appreciate. So starting with the question of jurisdiction, which we have raised in our preliminary objection, my Lord, I wish to refer you to civil application from the Court of Appeal in Nyeri, number E093 of 2023, Kawera Mwangaza versus the County Assembly of Meru. Civil application number E093 of 2023, Court of Appeal at Nyeri. Parties are Kawera Mwangaza versus County Assembly of Meru and the Speaker of Meru and the Speaker of Meru. My Lord, in this matter, it's in our list of authorities at paragraph 22. The Court of Appeal found that they do not have jurisdiction. Oh, sorry, my Lord, at paragraph 21. They do, yes, my Lord. They do not have jurisdiction in the first instance to consider the merits of the application for conservatory orders before the impeachment process has run its constitutional and legal course. They downed their tools at that point because the matter was pending before the legislature. They then proceeded to say that Honorable Mwangaza still has an opportunity to appear before the Senate, and if she is impeached, she still has the right to approach the court for appropriate relief.
Until?
Sorry, my Lord?
Until?
Oh, I'm saying, and after that, the court proceeds to say that if the petitioner, in this case, Honorable Mwangaza, is impeached, she still has the right to appear before the Senate. Okay, let me go back. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. They then proceed to say, even runs its course, she still has a right to appear before the Senate, and she still has a right to approach the court for appropriate relief. Yes. So at this point, the petitioner finds himself in the same circumstances as Honorable Mwangaza. He has produced the invitation from the Senate. He has produced the invitation from the Senate to provide his documents this evening by 5. He has produced an invitation to appear on the 16th and the 17th of October. My Lord, the Senate is the impeachment court. That is the trial court. The petitioner has a right to appear there, present his evidence, rebut what the National Assembly has presented to the Senate, and it is only once that is concluded that he can seek to invoke the jurisdiction of this court. My Lord, I also wish to rely on the Supreme Court decision of Karaoke Mate, which has been extensively cited this afternoon. Because if you exercise your jurisdiction and grant the orders that the petitioner is seeking, the effect will be to stop a constitutional process. And at paragraph 84 of the Karaoke Mate decision, the court said that no government, 84, the Supreme Court says no governmental agency should encumber another to stall the constitutional motions of the other. My Lord, the 10 days for the Senate are already running. If you issue a stay of those proceedings, it brings the constitutional process to a halt, or puts the Senate and the Speaker in a position where they have to decide whether to comply with Article 145 or to comply with decisions of the courts. And that was why Karaoke Mate had initially been convicted of contempt, because he was forced to choose between the two. My Lord, we ask that you allow the Senate to conclude and then give whatever appropriate reliefs. And at this point, my Lord, that is why the petitioners have been unable to demonstrate that their petition will be rendered nugatory if these orders are not granted. It will not. What they will do is to take the outcome of the decision in the Senate, which may even be in favor of the petitioner. He may or may not be removed. We do not know. And then approach this court for appropriate reliefs. At this point, nothing will be rendered nugatory if the Senate is allowed to proceed with its constitutional mandate. And my Lord, I wish to tie this to Gatirau Peter Munya's principle of public interest. The Supreme Court said